guys, it's me, Sylvia. Good afternoon, everybody. My apologies for being so late. What happened is I happened to get a phone call right before, like 3 minutes before my live started, and I'm like, dang, the time flew by so fast. I didn't even realize that it had at 12:30 had already passed. So please forgive me, and because I am not fully dressed, I got on my little workout clothes on. Well, let me show y'all. Hold on. Got my little workout clothes on. Look, my little workout clothes on, and I don't want to show my face and stuff. So just bear with me. I wanted to bring you guys some update on YSL Young Thug's case. I'm gonna show you a video first of some of the things they're gonna have to address in court this week. This week is going to be one of those weeks. It's not going to be boring because I am told by the attorneys, and I got a special guest. I'm gonna have some of the attorneys coming on this week, y'all. So do not miss this channel this week. Do not miss it because I will have some of the attorneys that's part of this case coming on to speak with you guys from their point of view, not the case itself because they can't talk about the case, but they could talk about the experiences and things like that. Well, let me go ahead on and show you the video of what they are experiencing in as far as the court system. Hold on a second. I'm sorry, I got food in my mouth. I apologize. just just a second. Hold on. Oh, come on. Trying to make this bigger. Gonna share this with you guys. Hold on.
Young Thug says she is case an attorney.
Hold on.
Tonight, an attorney involved in the high-profile case involving the alleged Young Slime Life gang and rapper Young Thug says she is ready to quit. The case is taking too long, and she says she's not getting paid enough to properly represent her client. Channel 2's Michael Seiden is live at the Fulton County Courthouse with the new developments. And Michael, to give everyone an idea, it's been 4 months now, and that's just been for jury selection.
Wendy, there is no end in sight. You know, these four attorneys, I talked to them, they told me what they are getting paid is an absolute joke. They say it's impacting their livelihood, and they said that if they don't get more money soon, they may have to drop this case.
It's bigger than just like, we just want money.
Inside an office building above Midtown Atlanta.
A case of this length also not only affects the indigent clients, but also our paying clients.
I did not know what I signed up for.
These four appointed criminal defense attorneys told me they are fed up, claiming they aren't getting paid enough to properly represent their clients, who are all co-defendants in the sweeping Young Slime Life gang case against hip-hop superstar Young Thug and his alleged associates.
We're doing it as conflict attorneys. That's the equivalent to a public defender. Public defenders are public servants. Nobody does this to get rich. However, nobody knew what they signed up for.
Appointed by the Georgia Public Defender Council, the state-funded group is paying each attorney $15,000 to represent their clients at trial, regardless of how long it takes. But right now, there's no end in sight. In fact, these attorneys say they were told to expect the trial to last 9 to 12 months, but 4 months in, and jury selection is still ongoing.
I didn't know that I would be there every single day, and I'm not able to take any other case. I'm not able to go to other court hearings. I'm not able to do anything else.
Angela D. Williams' comments come just days after she filed a motion to withdraw from the case. She also sent a letter to the GPDC requesting a sit-down with the director so they can talk about getting more money. But in a statement, a spokesperson told us in part, the agency is open to meeting with the attorneys, though their demand for a payment of $33,260 per attorney and at least $15,000 per attorney per month going forward present considerable challenges.
I'm going to stay in the case till it's over. But in the future, if you want anybody to step up and represent people that have a right, a constitutional right to an attorney, if you pay them or you're trying to pay us, nobody's going to do this.
Of course, there's 10 other defendants, including Young Thug. Now, I can tell you, if these defendants end up losing their counsel, well, they'll have to go out and find new counsel. And that's why these attorneys say that other private attorneys will see what's going on. They won't be able to hire anybody, and that could jeopardize their case. Finally, they say that state lawmakers need to do a better job funding public defenders. They say not enough money is being invested in that side of the prosecution. For now, we are live in downtown Atlanta. Michael Seiden, Channel 2 Action News.
And it is slow going at that, too. Michael, thank you. So this case against rapper Young Thug and the alleged Young Slime Life gang ramped up last May, when 28 members of YSL were indicted. 8 of them, including rapper Gunna, took plea deals to avoid prison time. Jury selection started in January and has been delayed several times, once because of a drug deal in the courtroom. Another 600 jurors were summoned just last month.
All right, guys. Woo, 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 woo. We got a lot to talk about. We got a lot of emotions that we got to go through, guys. Oh, thank you. Thank you, thank you, Kimberly, for the Cash App, y'all. I love this bell, y'all. Y'all make this bell ring for me today. Make this bell ring. But anyway, guys, we got a lot to go through. I know I have not been on to give you guys updates on the YSL case. My apologies, but I've been on the R. Kelly case because it's been a lot of stuff going on, a lot of traffic going on with that. So to all my YSL family folks, hey, sorry. Now I'm going to give you guys what I got for my YSL peeps. So we're going to begin with some of the footage that I have from this week. So let me go ahead on and put my little randy dandy thing in here. Hold on a second. I have to put my little SD card in here so I can show you guys the footage. So thank you guys. Don't forget to hit the like button when you're going in or going out, whichever one is easier for you. I appreciate every single one of you guys who support this channel. Please continue to support, because your donation helps me to continue to travel, continue to do the research, and continue to be able to come here without any hiccups. So please, if you have a couple of cha-ching, go ahead on and support this channel. I do appreciate everything that you guys do. Also, as well as hitting the like button, because that helps the information to go to other people, right? So let's go. Hold on. I'm trying to get this thing here. And everything that you do helps this channel, get these SD cards, these equipment. Shout out to all those who supported in getting the equipments that we get here. All right. So I don't think I showed you any kind of footage from the 11th. I got the 11th. I got the 12th. I got all of these footage for you guys. We got a lot going on here. So here's the footage from the camera folks from the 11th. I think it's no, it wasn't the 11th. That was the 3rd of April that the young lady got arrested. Remember the juror? Guys, I haven't shown the footage on the juror situation where she got arrested. I do have that for you guys. 1 second. And it's on silent, so there's no volume on this one. Thank you, Edward. Thank you for the super sticker. I appreciate you, Edward. Thank you. Shout out to Edward and shout out to Kimberly. These individuals just helping the sister out with the channel. But okay, let me go ahead and show you guys what is going on in the courtroom. I've been neglecting you guys, but here, this footage here, you're not going to hear the sound. So just bear with me. This is when the young lady who was doing videotaping during the trial, the jury selection. And hold on a second. Let me put my logo up because folks was trying to steal my content. Guys, did you get a chance to see me on All Vira Access? I was on there yesterday, and shout out to him. Shout out to all my fellas that I've been doing some collaboration with, because you need collaboration, and I need it with the big folks. And so shout out to him, shout out to Getty's gang, shout out to IQ, shout out to all the fellas who have latched on and helping the sister out, because it's a dog world in this YouTube world. So shout out to them who embrace the sister. But go ahead, let me go ahead on and push this in here so you guys get a chance to see. Let me know if you have a problem seeing what's going on. And this is from I think the 3rd. This is when they did the hearing. So it's nothing, no volume on this, because I think the camera person forgot to put on the volume. So if anybody say, oh, there's no voice, no sound, it's because they did not allow it to get on today with that one. So you guys could ask me some questions as you view this footage. This footage was from, oh, thank you. Shout out to Rosie for the Cash App. Thank you, Rosie. Thank you, Nosy Rosie. Appreciate you, sis. Appreciate all 3 of you guys who just donated to this channel. Again, remember, your support is definitely, I just don't need the likes. I need everything. I need your presence. I need your likes. I need your funds. I need all that. All right, this is when the judge come in. Everybody gets up and they doing the they come in, you see Steele's putting on his jacket. So I'm gonna try to do some little commentary in between this. All right. Oh yes, I did hear Ronnie Bo's video. I played it, Raquel. I played when he first gave it to me. He sent it to me and I played it. I was one of the, I don't want to say first. I was one of the people that got it, earlier than a lot of folks. He sent it to me. But I did play it on my live I did it on my members only live. I played it for them because I found out that when you play it, there's a copyright strike, because he has it on Spotify, Apple Music, and all that. And he sent me where he's like number 19 on the chart. Isn't that awesome? Woo woo! Go Ronnie, go Ronnie. Number 19 on the charts. That is awesome. Way to go, Ronnie. Hey guys, you see how the different angles you can see here? You see it right here. You see, this is the courtroom where the family is normally is. You see this is kind of empty right now. And that's because nothing has been happening in the courtroom. When I first started back in January 9th, the whole family was there. Everybody was there, right? How did it sound? It sounds awesome. Y'all put the link in for that song for Cool P. I wish I could play it, but because it gives me a copy strike, I can't play it on my regular channel. But I could play it on my backup channel for y'all, and y'all can hear it. Because I don't care if they hit my backup channel with the strikes. See, the thing with these, when you get these little strikes, it counts against you. So I don't want anything counting against me. All right, so the judge came in. He's doing roll call and things like that. And you see Young Thug there. But you know what? That's the third. You know what? Hold on. I got to go back for a minute. I'm going to stop this because I'm going to go back. This is the one before the what's the name? Hold on. I'm going to go, I'm going to pull up the young lady getting arrested. Hold on a second. She got arrested from court. I know some of you guys have already seen it on Law and Crime because they showed it. They showed the video. You know what? Let me see. Let me play that one first, and then I'll go ahead and show you my footage of it. Hold on. Okay, hold on a second. Let me share that one with y'all. This is Channel 5 covering it here. Hold on. Let's see. Shout out to Channel 5.
The young Slime Life gang gets the case that drags on into a fourth month. And today there was some drama in the courtroom. Good evening, and thank you for joining us tonight. I'm Russ Spence.
I'm Courtney Bryant. A potential juror in the YSL trial was arrested, accused of recording video during courtroom proceedings.
Fox 5's Christopher King joins us now from the Fulton County Courthouse tonight. And Christopher, you talked to a legal expert about how serious this violation is.
That's right, Russ and Courtney. That potential juror's out of jail after several hours. The judge initially sentenced her to 3 days. We speak with a legal expert. She says this judge is not playing around.
Sir, would it be fair to say that if you were selected for jury service...
Jury selection in the Young Thug trial heads from month 4 and more setbacks. The judge slaps a potential juror with jail time. Her offense, shooting video of courtroom proceedings.
Which is absolutely against the instructions that the judge has given.
Mo Ivory is a professor at Georgia State University's College of Law and director of the Entertainment, Sports, and Media Law program.
Folks are coming into this particular trial and they're not respecting the law, and they're not respecting the judge's courtroom, and they're not respecting the judge.
Juror 1004 arrested Monday morning. She's accused of recording proceedings on March 17th. The judge ordered deputies to take her phone.
He can decide whether to just dismiss a juror with a reprimand or, scold them in front of everybody or have them arrested and put in jail.
Ivory calls the potential juror's behavior improper and unlawful.
It's just not allowed, and it's completely inappropriate. And the judge told you it was completely inappropriate to do things like this, and you did it anyway.
Judge Earl Glanville reportedly complained the potential juror's actions could jeopardize the trial.
At any time, the defense is going to be trying to find a way to create a mistrial.
The rapper Young Thug, whose real name is Jeffrey Williams, is accused of leading a violent gang called YSL. His lawyers say he's innocent. The juror's arrest is the latest disruption in a lengthy case that's seen people trying to sneak contraband into the courtroom and a drawn-out selection process that hasn't seated one juror.
I think we all want to make sure that the justice system is carried out fairly. If we just take it slow and do it the right way, then a fair trial will happen.
Professor Ivory says above everything else, the juror must comply with the judge's instruction. After all, she says, the fate of more than a dozen people is in their hands. Live at the Fulton County Courthouse, Christopher King, Fox 5 News.
Yeah, still hard to believe after these many months that still not a single juror seated. Christopher, thanks very much.
All right. So, guys, that was the part in I got a few more section on that one. That juror, basically, she violated the judge's order, not to record during the orientation. She came to orientation, and she had her phone. She had like down on the bottom, and she went on live. And one of the jurors behind her saw her doing it, and called it to attention of the deputies. And then the deputy took her phone away, and so she had to come back to face the judge regarding her violation. So when he did her, well, let me just go ahead and play this for you guys. This is from Crime and Law Network. They're the one who gave you a full view of it. Hold on a second. 1 second.
On the 17th of March of this year to begin the jury selection process. Is that correct?
Yes, sir.
All right. And during that particular process, do you recall, and let me back up just a second, because of conduct that occurred or alleged conduct that occurred on the 17th of March, you were served with a order to show cause. That was filed on the 20th of March of this year to appear on this date, the 3rd of April at 10 o'clock in Courtroom 1C. You received a copy of that notice, didn't you?
Yes, sir.
All right. And that notice also gave you sufficient notice that as to why you should not be held in willful contempt for violating the court's admonitions against improper jury behavior, specifically live streaming the jury selection process on Friday, March the 17th of 2023. Do you recall that? I'm going to include that as a copy of the next court exhibit in order. That's your notice that we gave you. So you are at this point in time, why shouldn't I hold you in willful contempt?
Okay, so I'm going to explain everything that happened that day on the 17th of March.
Okay, but before then, do you recall this court giving you the ad nauseum admonitions about acceptable behavior?
About having phones out?
Yes.
At the moment when we came in.
Didn't I tell you to turn your phone off?
It was, I'm going to be truthfully and very honest. When it was a lot going on, we had just come from different
Answer
floors.
my question first, and then you can explain it. Do you recall us telling you to turn off your cell phones?
Yes, sir.
Okay. You also recall me going through a litany of different things that would cause us to potentially put the case in jeopardy. Do you remember me saying that to you?
I mean, I couldn't hear. It was so much people. It was so many people talking and so many people doing different things. So
people were talking when I was giving that admonition to you, meaning that you didn't hear it. You didn't hear any of the 10 minutes that I went through on the record about the things you couldn't do. Specifically, you couldn't research on Google. You couldn't go ahead and otherwise contact your friends on social media. Do you remember that?
Well, I remember the part when you saying we had to, but I didn't hear the turn off the phone.
Remember me talking about no social media?
Yes.
Do you remember me also pointing to the placards that are on the wall about social media and the things you cannot do?
And I didn't see that until after the fact.
You don't recall me pointing that out to you?
No, sir.
But you were, in fact, told to, one, put away your phones, and two, that you could not otherwise, you do remember, you couldn't otherwise post, pin, tweet, or otherwise.
And I didn't.
Send anything to social media.
Correct, I didn't.
But you did live stream our proceedings, didn't you?
It wasn't live streamed at all.
So what exactly did you do then?
Okay, so when you was giving the speech, everybody was talking. I did take a video, and then the young lady next to me, she was like, "Man, we're not supposed to be recording." Soon as they said that, I deleted everything right then and there. Maybe An hour went by. That's when the officer came up to me and said, somebody had told us that you may be recording. So I showed them the phone. They went through my recent deleted photos and seen the video that I made, but it was already deleted because the young lady next to me had told me that you did say we wasn't supposed to be doing any of that. And this is my first time. That was my first time ever being in court in my whole entire life. So I wasn't really sure of anything we couldn't and could not do. So I do apologize for that.
Madam, I went through a very long and arduous process of telling people what they could not do.
Correct.
And you violated that. And you put this trial in jeopardy because of doing that, because of your actions of that. And I told you that the reason that we put such a big emphasis on this is because people actually do this kind of stuff. They go ahead and they take pictures. They go ahead and visit the scene. They go ahead and talk to their friends on social media. They talk about and try and learn things about the case that they're not supposed to. Aren't presented in the four walls of this courtroom.
Yeah, it wasn't posted on social media or any type of.
Well, I know that, but I told you don't even get on your phones and to not record anything.
And I told you that into the middle of the court.
Well, the lady sitting behind you saw you when it saw you going ahead and videotaping these particular proceedings, and that was in violation of this court's order. So contempt is punishable by a fine of $1,000 and or 20 days in jail. Madam, I think that given the amount of time and energy and effort and care we spent in making that particular pronouncement, and I tell it multiple times for multiple reasons, and you decide you're going to just do what you wanted to do.
It's not
pull out your phone
doing what I wanted to do.
Well, you pulled out your phone and videotaped our proceedings, and that was in direct violation of this court's order. So I'm going to sentence you to 3 days of in jail, and that will otherwise satisfy your contempt. So
it's not going to be the payment. I thought you said.
No, I'm not going to fine you $1,000 because this court, I've given this same admonition a number of times, and there are varying reasons that we punish people in society. Okay, I'm just going to tell you the reasons are: one, just general is retribution, eye for an eye. The second reason that we punish people is for general deterrence. We don't want other people doing this kind of same thing. Third reason is specific deterrence. That means we don't want you doing this again. And then it's rehabilitation and reentry. So, ma'am, in this particular situation, unfortunately, I have told several people and made several iterations of this particular notice. And you videotaped our proceedings. It was just a brazen violation of these particular proceedings. I told you not to. If you just left your purse in your pocket, you would have not even put yourself in this particular predicament.
Right, but there was so much going on.
That doesn't excuse your behavior, and doesn't give you.
I didn't hear every.
Madam, that does not excuse your behavior, and it doesn't provide. It's an excuse for behavior, because there is no reason you couldn't have taken your phone and put it in your purse when we told you to do that, right?
Correct.
Instead, you took your purse out. You had to go through several manipulations to turn on the video feature for you to go ahead and videotape these proceedings. Is that right? It just didn't come on by itself, right?
Yes, sir.
So that's willful. That's you like saying to me, Judge, I don't care what you said about this kind of behavior. I'm gonna do what I want to do. So for that reason, that's why I'm gonna hold you in contempt for 3 days, and that will otherwise satisfy your contempt.
Okay, here come the police.
Your Honor, you ready to take it in custody?
Yes, ma'am.
Oh wow, they took her into custody. Hold on, let me show you the other part. Just 1 second. Trying to get the other station that has it. Just 1 second, y'all. So how's everybody doing? Y'all hitting the like button, y'all? Y'all hitting the like button. Are y'all hitting the like button?
Would compensate him during.
Hold on a second. Just a moment. Just trying to pull up the second part of that hold hearing.
Not to concern myself with, but that's transport, and I'll let them work. And with.
I needed it.
And how long have you been with OG?
About 3 years.
And you were with them full time?
Well, yeah, it's
Okay.
my own business.
Hold on a second.
Okay, so are you a franchisee or?
No.
Or how would you tell me how your business structure is set up?
Well, I'm the coach. I have 3 employees, and I basically operate 7 days per week.
Do you have a hard location or like a building or?
No, it's all online, so I work at home.
Okay. What did you make last year? I can ask.
About 150,000, but currently I'm making 25,000 to 35,000 per month.
Okay. Sir, do you own a home, have a mortgage?
I live in my family's home that is paid off.
Do you pay your parents any rent or any associated expenses?
No.
Okay.
Well, I pay like HOA and regular home fees.
For your parents?
Well, not really. I mean, it's for myself.
Okay, who owns the house?
My parents.
Okay. Do you have a car note or any other car insurance?
Just car insurance.
Okay. Any other extraordinary expenses that you have or every month that you want to share with us?
I mean, my expenses are pretty much covered very well. I mean,
Okay.
Yeah.
All right. What do you have in savings and checking? Total, just a guesstimate.
Just about 100,000.
Okay.
Must be nice, y'all. 100,000 living in
Your
his
fitness
parents'
training
home.
that you do, what hours are you doing or conducting this training?
I'm doing I've got an assistant coach that does most of the operations, and I do mostly the sales. And I do like live trainings for my clients twice per week.
Yeah, come on, get
And
the
what
light
time
button.
are those live trainings conducted?
12 p.m. Monday, Thursday.
What other, you own the business, is that what you told us? Is that correct?
That's right.
So what other supervisory, other ministerial functions do you carry out on a daily basis?
I don't understand the question. Can you?
Okay. What do you do on a daily basis for your company in order to run it?
Oh, I do sales videos. I do lead generation.
Okay, how do you do lead generation?
I basically do a sales process funnel through conversation, and then I get their client application, and then I have to do about a 20-minute sales video presentation to acquire the business.
Okay, so if somebody wants to sign up for your services, basically you solicit the business during the daytime hours, follow up on that, and make sales pitches to individual people. Is that correct?
Exactly.
Okay, all right. And
VK, you wrong for that.
and your employees, that's your unique function being the owner. Is that correct? Is generation of new business, right?
That's right.
Okay. So if you were here for about 6 months, would it be fair to say that you would probably lose about $75,000 in income at least?
Yeah.
Would you not being able to, being present every day to generate leads and otherwise make sales, would that put your business in financial peril or concern?
Yes, it would, because the timing of it's pretty important, because, you know, they're emotional at the time and people buy from emotion. If I take 1 to 2 days to get back to them, they're probably going to find another opportunity.
All right. Would that peril or concern cause you to not be able to come into this courtroom and give the testimony presented your undivided attention?
Yeah, it definitely causes stress.
Okay. Would that stress also prevent you from being fair and impartial both to the state as well as to the individual defendants in this case?
Most likely, yeah. I'd probably be bitter about it.
Okay. And would that bitterness prevent you from being fair and impartial to both sides? The state as well as each individual defendant?
I mean, I don't think it would change my opinion on the whole situation, but
you'd be bitter. Is that right?
I mean, I would be losing.
Okay, let me just kind of go back just a second, Juror 1206. I tell people all the time, there's no right or wrong answer to this whole procedure, just honest answers. So we're going to be bound by whatever you tell us.
Okay.
And nothing bad or harmful is going to happen to you. Like I told you the very first day that you came in here, one of the beauties that we have in American society is that redress of grievance of governments. And that means you can pretty much say what you want within reason to government and its entities. So we'll be bound by whatever it is you tell us, okay? So the lawyers in here would like to know your honest answer. So would your bitterness of the fact that you're possibly going to lose your ability to generate income,
Look what Koopy said.
affect your ability to be fair
Koopy
and
said just bring
impartial,
retired
both for the
unemployed
state of
people.
Georgia
How
as
about
well as
that?
to each individual defendant in this case?
No.
Okay, so you could be fair and impartial, but this bitterness and concern would prevent you from not being able to give this case your undivided attention. Is that correct?
No, it wouldn't.
So you could still be fair and impartial to both. I'm sorry. So that means you could listen to this testimony presented in this courtroom, and despite the fact that you're probably going to lose most of your business income, you could be fair and impartial. You could give this testimony your undivided attention. Is that what you're saying?
Yes.
Okay. So you could give. And how would you pay the rest of your bills and your obligations?
With whatever income I get and my savings account.
Okay, so you have about $100,000 in savings. That's what she said, right?
About, yep.
So so despite the fact that you had to probably use this $100,000 in savings, that would be something you could bear. Is that correct?
Yes.
Would you hold the fact that you had to spend some of this $100,000 in income against the state as well as the individual defendants in this case?
I mean, I got goals.
Okay. Look, like I said, Juror 1206, there's no right or wrong answers, just honest ones. And so if you tell us, hey, you can't be fair and impartial, that's one thing. But if you tell us I can listen to or fair and impartial and pay attention. So there's two things. The first thing is, just from looking at your circumstance, your business is probably going to suffer significantly, as well as you're going to probably have to spend this $100,000 that you have in savings. Correct?
Yes.
So despite that, you could still listen to the testimony presented in the four walls of this courtroom, and while you're here, give it your undivided attention. Is that what you're saying?
Yeah, I'm a fair, honest guy. I can definitely do what I have to do.
He sounds
okay,
weird.
You do what you have to do. Would you have any soreness or disappointment?
Don't he sound weird, y'all?
Hold that against any of the parties in this case because you're having to spend your own money to be here?
Yes.
All right. Anything further? Anything further to have any individual defendant?
No, sir.
All right. May I excuse Juror 1206 for hardship?
You have no objection.
All right. Sir, I'm going to excuse you for hardship and wish you all the best, okay?
All right.
Thank you.
Yeah, Richard. Richard, I agree with you. Weird. That was a weird one.
That's fine. Can you get Captain Campbell for me, please? All right, councils, we're going to just recess in place. We have two more people to examine, so I'm not going to release everybody at this point in time. Come on, let's go.
Come here. Yeah.
Yes, sir.
VK, she's been here since the other one left. Let's forward this a little bit because it's like boring right here.
You get that's a trick, Mike. it's on Jonas. Yeah. Got good plans this week. Oh, we try it again or maybe would you mind Oh, no, she's here. She's still here. She hasn't called me. She said she got to check her schedule. That's nice. Might be next weekend. So that would be the weekend. Better for her. Why are you 30? Okay, folks, we're going to go ahead and get started again.
So we can finish up? Mr. Randolph, 1209 for me, please.
Yes, sir.
Thank you, sir. Your mom?
He does help when I go, in the evenings. If he's home, my sister also helps.
Oh. Be well, okay? Thank you. And the care that you have for your students, and about how, coming out of this pandemic is really wreaked kind of a little bit of havoc on the educational system of all of our children. We certainly acknowledge that. And we certainly acknowledge you wouldn't be employed with Fulton County if you didn't care and love about your children. Fair to say?
It has been rough. Thank you.
All right. But, sir, do you understand if you were selected for this jury that it would be the school system's responsibility and not yours to figure out how they're going to make up the coverage? It would not be your responsibility?
I understand that.
Okay. The question that I have and the lawyers have for you is, we also know that from having examined a number of people in the school system, Fulton County will pay you while you're here if you're selected for jury service. Is that correct?
As I understand it, yes, sir.
Yes, they will. Okay. All right. So the lawyers need to know, can you and will you, if you are selected for this particular jury, could you come into the four walls of this courtroom and give this case however long you're here for each day, be an hour, 3 hours, 5 hours, 8 hours, your undivided attention?
If called upon, yes, sir.
Okay. All right. Sir, and would you be fair and impartial both to the state of Georgia as well as to each individual defendant?
I would.
Okay. Sir, what is your work-related hardship, or have I examined you sufficiently enough as to that?
According by the duration of the trial, as was communicated at our first meeting,
yes,
I would require a long-term substitute to satisfy to fill in for me.
That's not your responsibility, remember?
Correct.
That would be the school system's responsibility. So is that your concern?
Could you repeat the question?
Is that your concern?
No, that would not be my concern.
Okay, because I told you just a second ago, if you were selected, the school system will figure out that problem. That's not yours to figure out.
Right.
Okay, so what's your hardship?
The
work-related wise.
The loss of a consistent teacher to the students.
Okay, we talked about that just a second ago. Because anybody worth their salt is going to be concerned about that. But you understand that your focus, if you were selected, would be this particular case and its particular parties and issues. Could you do that while you're here?
Yes.
Okay. All right. Anything else, sir?
No, none that I can.
It relates to hardship?
No.
Okay. So I believe we're going to have to examine you further, and I can tell you that will probably occur at least a couple months down the road. So what I'd like to do at this point in time is just kind of go through a couple of things with you. The first one is, you remember the juror letter that we gave you that has your unique juror number on it and the number you're supposed to call after hours?
Yes, I do.
Okay. It's going to be a couple of months before we reach back out to you, but we will reach back out to you. We'll probably call you as well as publish something on that particular line. So just kind of keep looking for that, but don't be overly concerned if we don't call you, you know, in the next week or next couple of weeks. It's going to be a minute. So that's the first thing.
Thank you.
Second thing is, you remember the ad nauseum admonitions I gave you about acceptable behavior?
Yes, I do.
You're still subject to them. And then the last thing I would share with you, sir, is thank you for your patience that you've given us thus far and will continue to give us. And with that, unless there's anything else, we will be back in touch with you, okay?
Thank you, sir.
All right, thank you, sir.
Okay. So this was the jury selection thing. This is like from the week before. Remember, haven't been around in a while, so I'm just giving you guys some brush up with some different ones, okay? Let me see. I don't know if I think we showed you the 11th. Let me go and see. Let me see if I have some new ones. Hold on a second, y'all. Then we're gonna go over the motions, okay? It's been a while. It's been a while, so I'm just trying to do catch up with you guys. I know I deserted y'all. Apologies. Okay, I'm gonna go ahead and play this one here for you guys. All right, here we go. Big court day for Jeff. Oh yeah, it's gonna be a banger tomorrow. Tomorrow's gonna be a banger, y'all. We're gonna have some. So y'all better stay tuned. Be ready to hear what the stuff that's gonna happen. There's gonna be showdown tomorrow.
All right, Mr. Brown and Ms. Hilton, good afternoon.
Bunch of motions tomorrow.
Mr. Randolph and Ms. Von Kels, good afternoon. All right, before we begin, Ms. Von Kels, any administrative announcements, madam?
Yes, Your Honor. The second juror 951, has a language
I think we did this one already. The one with the Spanish speaking one.
All right, well, once we
that
see Mr. Lyons, we can take 951 out of order, okay? Anything else? Okay, all right. Let's start off, Mr. Randolph, with 945, please. Thank you, sir. Juror 945, good afternoon.
Good afternoon.
Sir, do me a favor and speak directly in the microphone so we can all hear you, okay?
Good afternoon.
Okay, wonderful. Sir, you identified for hardship, we identified you, and that basis is based upon transportation, is that correct?
Yes.
All right, can you tell me a little bit about it so I can grade or evaluate it?
I do not currently own or possess a vehicle to regularly make my way down here. I live an hour drive away from here.
Where do you live, sir, in our county? Not your street address, but can you give me the area of town you live in, like Roswell, Buckhead, Alpharetta, Johns Creek?
Alpharetta, near the border of Milton.
All right. How'd you get here today?
I got a ride from family.
In terms of your employment, we have a little bit of information about you. It's self-provided. So you're an analytic developer and you work for Integrated Analytic Solutions. Is that correct?
Yes, sir.
How long you been with them?
3 years now.
How do you get to work for them? You work at home? You go to a hard site? Tell me how you get there.
I work at home.
So family, how'd you get here the first day you were called for jury service?
I got a ride from family.
So you own no car?
No car.
What do you do when you need to go someplace else, either socially or for work or for anything else?
I rent a car, or if it's available, I borrow a family car.
How close is the MARTA to you?
Roughly a 30-minute drive.
Sir, I don't know if transportation ordinarily would be a reason to exclude you for hardship. The law only gives me a limited number of bases for us to go ahead and provide you relief from hardship. People from all over our county, north, south, east, and west, tend to make it to the courthouse.
I understand.
Would it be something you just have to figure out with your family's assistance? You live at home with your parents?
I do, but I would have to purchase a car to make it down here regularly.
Let's talk a little bit about your employment situation. And then there's a reason for it. How long have you been with Integrated? You said you've been with Integrated 3 years, right?
Yes, sir.
You salaried or hourly?
Hourly.
How much do you make an hour?
I believe it's $28 an hour.
$28, okay. How much did you make last year? Just
I believe
guesstimate.
76,000.
Okay. And let me ask you some other questions ordinarily be none of my business. Do you happen to know what your company's juror policy is?
I have a copy of it with me.
Can I see it?
Yes, sir.
All right. If you wouldn't mind handing that to Deputy Ingram for me, please. Thank you, sir.
It's the last section.
Okay, Juror 945. I'm in possession of the policy, but it looks like you need to tell them, as your employer, if you get selected for jury service so they can cover your job or duties. Is that correct?
Yes, sir.
Do you have any more of this policy or did you talk with HR about how much they would cover?
I believe that's the entire policy.
So will they pay you no matter how long you're here for?
I do not know.
Can you do me a favor and if I were to release you to go outside and call your HR and Integrated and kind of just say, hey, is there anything further to 6.10 jury duty and see whether or not they are in fact going to pay, cover if you were selected for jury duty of up to 6 months or greater, would they pay you? Because it doesn't, this is kind of just, it stops. It says, Employee must bring in the jury duty notice as soon as it's received, so the appropriate arrangements can be made to cover his or her duties. Or employees are required to call in and report to work for those days or parts of those days where their presence in court is not required. It doesn't say anything about length, or it doesn't kind of just say if there's anything further to 610 in this particular section, okay?
Okay, I can contact them.
Okay, if you'll just step outside and let Mr. Randolph at the door know when you're back, I'll include this as a next court exhibit in order once our juror completes his inquiry. You can come back, okay?
Yes, sir.
All right, in the meantime, Mr. Randolph, 975, please.
Yes, Your Honor.
After this footage, y'all, I'm gonna start reading off the motions, okay?
All right, juror 975, good afternoon, madam.
Good afternoon.
So once you get settled, pull that chair up as close as you can to the microphone, speak directly into it so we can all hear you, okay?
Okay, thank you.
All right, wonderful. Madam, you either identified for hardship or we identified you. And three bases I have financial, transportation, and medical. Is that correct?
That's correct.
All right, madam, do you have any documentation or an affidavit from your doctor?
No, I do not. I just have diabetes and a lot of metal in my body that makes it difficult to sit.
You said what type of diabetic are you, madam? If I can
Type
ask?
2.
So do you take medication?
Yes, I do. I take metformin and Farxiga.
Okay.
Yeah, we've seen this one already, didn't we? I showed this the other day.
The last thing you said you had diabetes, and did I hear you say you have a lot of metal in your body?
Correct. I've had both my right knee and left knee completely replaced.
Yeah, told me.
Didn't we do this one already? I think we did it on the 11th. I don't want to hear it again. Yeah, we did. Okay. Thank you for reminding me, y'all. Yeah, we don't need to see this one again. So let me go ahead on and start with the with these motions for you guys. Hold on. See, it's been so long that I forgot about you guys that all right, how much likes do we have in the chat? How's the likes looking like, mods? Are we okay with the likes? Are they treating us bad? Or are my folks treating us bad? But anyway, guys, but I do appreciate the ones that have hit the like button. It's much appreciated. I know I always hop on the ones that don't, so I have to give the credit to those who have already hit the like button. I appreciate you guys. I love you, love you, love you. Love you guys so much for doing that for me. All right, so we still got some folks in here who are defiant, but that's okay, Lady Coaching. We're still going to keep moving. We're going to keep moving. Keep on moving. Oh, we good? Oh, okay, 40. All right, good. Only three people. Okay, that's good. That's not bad. That's not bad at all. All right, let's go ahead on and get on with these motions, guys. Let's do these motions and see what it's going to look like. As I told you this week, you don't want to miss this channel. You better stay tuned. It's going to be off the chain. It's going to be off the chain because it's going to be a week of motion because I told you guys I'm going to have some of the the attorneys. They're going to be my guests on the channel. Yeah, I can't wait, huh? And from what I'm being told, let me read the text message that I got from one of the attorneys, because I'm gonna have them on. I have at least 4 of them on my live sometime this week. One attorney says, tomorrow we have some good content with these motion. I'm going to argue and we can talk after court. Woo! Woo, woo, woo. Y'all, look at this. Your girl doing it. Your girl getting it, that impersonal interview with the lawyers, y'all. You know it. And that's why I want you guys to hit the like button. Come on, hit the like button. Support this channel because your girl's out there working it for y'all. I'm working it. I'm working it. Hey, Black Beauty. Hope you're feeling good. Much better. I'm working it, y'all. I'm working it for you, girl. Thank you, Sierra. Thank you. So tomorrow I'll have one of the attorneys, and then the next day I'll have another one, and the next day I have another one, and the next day I'm going to get a whole bunch. And then the big one at the end. And, you never know what you could get off this channel. You never know who you might see up in here. Because girlfriend is working it. That's right, Angie. I'm doing that dang on thing. I said dang. I know what you said. I said that dang on thing. Yeah, so I got a big Kool-Aid smile on my face from ear to ear because I reached out to some of the attorneys and I told y'all, your girl gonna do it. She's doing it well, doing it well. Thank you, Steph. Thank you, Galatians. See, God's got me, y'all. God's got me. All right, so I don't know. I might make it members only when I do these interviews because it depends on these people, how they act out here. I might do a members only. Yeah, I might do is members only with the attorneys. I don't know. It depends on how y'all act out here, how y'all treat your sister. How you treat your sister. Depends how you treat your sister. All right, y'all, let's go ahead. Let's get on. Let's get some work done here. Hold on. Got to show y'all these motions that are here. Favor ain't fair, right? Right? Favor ain't fair. Yep, favor ain't fair. All right, let's get going. The first one is going to be Farley's motion. And I'm going to bring it up so you guys can read it. I'm going to bring it up. I had to get my watermark on this. Let me put myself in this corner here. And I'm going to present this for you guys. All right, here we go. All right, here we go, good people. This was filed November 11th, and it's from Mr. Farley's. Did I read this one here? Guys, do you remember if I read this one? Because we got... I'm not too sure if I read this one. But anyway, let me go ahead and read it just in case I didn't. I think we did this one. Okay, thank you, Courtney. Yeah, I did this one. Thank you. Courtney, you be on it. Thanks, Courtney be on it. Okay, so did we read number? We read motion in limine number 14 too, right? We read that one. Let me go to the next one. I think the next one we need is limine number 10, response from the government. We didn't read that one. Okay, let me go ahead and bring that one up for you guys. This is the motion that in response to Mr. Williams, in limine number 10. Okay, this is the government's response. Let's go ahead and read it, guys. Are you ready? All right. State of Georgia versus Jeffrey Williams, defendant, case number 22SC183572. State's response in opposition to Jeffrey Williams' motion in limine number 10. The state of Georgia, by and through the undersigned counsel, District Attorney Fannie T. Willis, hereby responds in opposition to defendant Jeffrey Williams' February 10th, 2023 motion in limine number 10. In support of this response, the state shows the following. Carly, I don't know, Carly. We're gonna have to see what happens. Carly, you're asking the wrong person because I am a lay person. I don't know none of these law things here. But tomorrow I will have one of the attorneys in here. It depends how you guys treat me today. I will make a decision whether or not I do it a membership or regular. So if they get my likes up so far, the likes have been gone up. So I'm going to give you guys kudos for that. So from right now, it looks like I will be going live with the attorney on the main side. Okay. So you guys can get your question prepared, and I'll let you guys know when and how long and things like that with the attorney, because I do have one attorney coming tomorrow, and then another attorney, and another attorney, and another attorney. So just stay tuned, guys. Stay tuned. Okay. So, Carly, that's a very, very good question that you can send to me, and I can ask the attorney ahead of time some of these questions, okay? Email your question to me so I can just copy and paste and send it on to the attorney before we meet, okay? But that's a very, very good question, and a question that I think that attorney should be able to answer. All right? All right. So, let me finish reading. Okay, February, let me start from... Number one, as an initial matter, the state asserts that this motion concerning closing argument is premature, as this honorable court is still in the process of jury selection in the trial of this case. The issue is not ripe for ruling, but be sure closing arguments are upcoming, but by no means imminent. Defendant is effectively objecting to something the state has not done, is not presently doing, and has no intention of doing in the future. Defendant is asking that this honorable court to expand the Alvarado versus state case number here vastly beyond the limit legal proposition for which it stands. In Alvarado, the prosecutor stated at the beginning of this trial, this defendant was cloaked with the presumption of innocence, but that's not a permanent status. That does not stay with him forever. Keep that in mind. Just because he has it in the beginning doesn't mean he has it now. Which was immediately followed by it is a burden, and I bear it, ID at 310. The purported error in the jury's instruction was raised as an ineffective assistance of counsel claim to the Court of Appeal, ID. The Court of Appeal held that this argument was unclear and not necessarily an incorrect statement of law. ID further. The Court of Appeals held that there is no merit to this claim because the prosecutor immediately clarified her argument and because the trial court properly instructed the jurors on burden of proof and presumption of innocence, which the state anticipate that this honorable court will also do in this case as at the appropriate time. ID. Number 3, the state is allowed to argue that a defendant's presumption of innocence is no longer absolute once the juror considered evidence overcoming this presumption. See Clark versus State 307, and then the case law. The presumption of innocence remains with the defendant throughout the progress of the trial, unless and until it is overcome in the mind of the jury from what is adduced on the stand. Under the rule of law as given by the court that the defendant is guilty beyond a reasonable doubt, Little versus State, punctuation and citation omitted. Also, the prosecutor may properly draw inference in closing arguments from the defense failure to produce witnesses and may comment on a defendant's failure to adduce evidence to rebuke the state's evidence. Gordon versus State, punctuation and citation removed. An argument that the defendant has not rebuted or explained the state's evidence does not amount to an improper burden shifting argument. William versus State, the case on that one. A recent Court of Appeal decision explicitly holds that jurors are allowed to consider a defendant other than innocent when starting deliberation. Quintanilla Solis versus State. Appeals state that there was no authority to support the notion that a juror upon hearing evidence presented during the trial must refrain from forming preliminary unfixed opinion about what the evidence might ultimately prove. And in fact, we have rejected claims, raised similar arguments to challenge jurors' impartiality. See Nelson versus State, where prospective jurors stated during a voir dire that her opinion would begin forming as the as she processed the evidence. No error in failing to remove her for cause, because there is no indication that the juror was so biased that she could not render an impartial verdict based on the evidence. Doss versus State. The life experience of any juror may trigger a response to evidence presented during a trial. We ask jurors to be impartial at the beginning of a trial, not at the end after hearing the evidence. ID emphasis supplied. Even assume arguendo that the state misstates the law, which has not happened and will not happen here. A simple cultivated instruction containing the correct law is all that is needed to remedy the misstatement. Clark, Alvarado, Williams, Lesser versus State. Conclusion. For these reasons, the state respectfully requests that this honorable court deny defendant Jeffrey Williams February 10th motion 2023, motion in limine number 10 as premature, meritless, and seeking a limit that the state closing argument far more than is proper under correct Georgia law. Respectfully submitted, 13th day of April 2023, Fannie T. Willis, Attorney General, Atlanta Judicial Circuit, bar number, whatever the number is, and Adrian Love, Deputy District Attorney, whatever. Okay. So, and this is a certification. Everybody received that. Okay. That is that. Next one we're going to read is the state's response to opposition to Jeffrey Williams in limine number 14. These people are taking so long to respond to these motions that we forgot what these motion was all about. All right, there we go. All right, let's go. This is an opposition from the state to the motion that Mr. Williams put in this motion number 14 and this motion in limine, okay? The state's response in the opposition to Jeffrey Williams' motion in limine number 14. The state of Georgia, by and through an undersigned district attorney, Fannie T. Willis, hereby responds in opposition to defendant Jeffrey Williams' April 12, 2023 motion in limine. Number 14. In support of this response, the state shows the following. Number 1. As an initial matter, the state asserts that this motion in limine concerning potential witnesses' testimony is premature as jury selection is still going. Yeah, it seems like they did a lot of copy and pasting, don't it? Because it sounds like the same thing that they said earlier. This issue is not ripe for ruling. Defendant is attempting to object on something that has not happened and not happening and will not happen if they copied and paste this, y'all. They copied and paste. This is what you call lazy. They copy and paste. It's the same thing. We read the last one, number 10. Okay, number 2. Contrary to Williams' assertion that the Supreme Court of Georgia in Moreau versus State, whatever the numbers is on this, was not called upon to make and did not make any ruling on the issue whether lay opinion testimony from a law enforcement officer about his or her perception of a witness was admissible under OCGA 24-7-701. The High Court's only holding in this connection was that, assuming without deciding that the admission of this evidence was erroneous, any error was harmless. ID. The Supreme Court of Georgia held that the introduction of this evidence was harmless in light of other strong evidence of the guilt of the defendant in that case, including testimony from witnesses that they had been threatened not to cooperate with law enforcement. Accordingly, the state submits that law enforcement's testimony to the effect that a given witness is not cooperative with law enforcement out of fear is not categorized inadmissible. Contrary to what Williams seems to suggest, OCGA 24-7-701 allows the introduction of such lay opinion testimony, providing that the opinion or inference are 1. Rational based on the perception of the witness. 2. Helpful to a clear understanding of the witness testimony or the determination of a fact in issue. And 3, not based on scientific, technical, or other specialized knowledge within the scope of Code Section 24-7-702. Subject. To the above And with proper foundation, the state is entitled to elicit lay opinion testimony from a law enforcement officer, such as that described above. For instance, where such testimony is necessary for the jury to understand the steps that an officer took in his or her investigation. Bullard versus State, in the case number on that. No abuse or discretion is discretion in allowing admission of a lay opinion testimony from an officer concerning the identification of the defendant in a photograph based upon his prior interaction with the defendant. Atkins versus State, and there's a case law in that. No reverse error or intermission of officer's testimony that a witness knew the identity of the shooter, which was relevant to explaining his step when steps in validity of investigation was attacked by defense. United States versus Walker. Lay opinion testimony from eyewitnesses that a defendant appear afraid properly admitted under Federal Evidence Rule 701. Moreover, such testimony could be admitted as admissible as expert testimony. See Smith versus State. Expert testimony about gang culture and associated disciplinary rules properly admitted under OCGA 24-7-703. The state has not explicit inadmissible testimony and has no intention at any point in the future to elicit same. Williams' motion is prematurely seek to improperly limit the state's ability to introduce admissible opinion testimony in this case. Conclusion. For these reasons, the state respectfully requests that the Honorable Court deny defendant Jeffrey Williams' April 12, 2023 motion in limine 14 as premature, meritless, and seeking to improperly limit the state's ability to introduce relevant and admissible opinion testimony in the trial of this case. Respectfully submitted the 13th day of April, 2023, Fannie T. Willis, y'all know who she is, and Adrienne Love, y'all know who she is. I know their position, okay? All right, so that is that. All right, here we go. We got another motion. All right, this is Mr. Williams' request for discovery. Again, more discoveries not received yet. Okay, y'all ready? You already know the beginning, salutation beginning, right? So it's motion for discovery number 13. Now comes Jeffrey Williams by and through undersigned counsel, and hereby file this motion for discovery number 13 in the above referenced case. In support of this motion, Mr. Williams shows as following. Number one, Mr. Williams is innocent of all charges in the above referenced indictment. Number two, the prosecution has provided search warrant in the above referenced case. However, did not provide affidavit in support of said search warrant specifically. Mr. Williams respectively requests the production of the two affidavit for search warrant issued in or around late 2021 by investigator Lauren Crabtree for information related to phone number, blah, 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 and Google, Gmail, blah, 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 blah. Okay. Wherefore, Mr. Williams respectfully requests a hearing on this motion, and at the conclusion of the same, ask the Honorable Court to grant the above request relief. All right. So that is that one. Guys, we got one more. I think it's one more. I have to go check my email. One more so far. All right, now we are on for request for another discovery. Let me show this one to you. Hold on, y'all. All right, guys, here we go. All right, y'all ready? Y'all know the salutation again. Okay, the introduction, whatever, blah, blah, blah. You know, the state number and all that. It says motion for discovery number 14. Now comes Jeffrey Williams by and through undersigned counsel and hereby files this motion for discovery number 14 in the above referenced case. In support of this motion, Mr. Williams shows as following. Number one, Mr. Williams is innocent of all charges in the above referenced indictment. Number two, based upon information and belief, the prosecution has not provided the Instagram account return for Mr. Damikian, I don't know how to say the name, Garlington, specifically for Instagram handle at SXAR_FAXE. Wherefore, Mr. William respectfully requests a hearing on this motion and at the conclusion of the same, ask this honorable court to grant the above requested relief. On the 14th day of April, 2023, respectfully submitted, Brian Steele. You guys know that. Okay. Woo! I think I'm tired now from reading. What do you guys think of what we just read? Have I updated you guys enough yet? Just remember tomorrow, this week is going to be the week that is like some real action, I believe. Not that boring jury selection stuff, but some real action, some motions being set in. You guys are awake? You guys are still awake with me? Come on now, wake up. I need to see some interaction now. Come on. I asked y'all guys some questions. So what's the question? I mean, what's the answer? Maybe I should put some sound effects behind some of this stuff because you guys are just like going to sleep on me. We need to put some action behind this here. You sound so like bored, like Maybe we need to put some sound effects in there. Anybody up? Are y'all up, y'all? Hold on, y'all. Just bear with me a second. I'm trying to get the... I'm downloading some sound effects since you guys are being so boring. Wake up! Are you gonna wake up? Y'all gonna wake up? You're just listening? Okay, all right. So, but I'm finished reading. I'm here unpacking, starting dinner. Rosie said, listening, just finished cooking. I've been cooking since 6 a.m. this morning. What are you cooking, Rosie? The one who shot this at the YSL snitch. You're driving. Do you think they'll get out? Philip, I don't know nothing about. Don't ask me questions like that. I don't know. I'm just here, just giving you information, guys. I have no opinion. I'm just gonna give you all sides of it, and I give you like the stuff that you guys don't know about. You know what I mean? You're just back from the grocery store. LOL. I'm up. Question. Ask a question earlier. Oh, you did ask a question. You're not boring. LOL. Okay, thank you. But you guys are just like sleeping on me here. What is going on? Let me see if I get some sounds in here for y'all. Where are the sounds at? I gotta beep these people cussing when they come up in here, right? Let me see what else we got here. Let's see these sounds. Hold on. Hold on. I'm checking out these Uh-oh.
We're sorry. Your call cannot be completed as dialed.
Okay, here's what I've been hearing from you guys. That's what I've been hearing from you guys. Y'all been very quiet on me, so I had to be like, what? Game over, y'all. Game over. Y'all making this whole live sound like this. Flushing it in the toilet, let it go. Thank you very much. Thank you very much, y'all. Thank you. Oh. I'm being this, right? I'm being a real crybaby. I'm being a crybaby, am I not? I'm being a crybaby. That's how I feel when y'all don't give me no likes. I be like this. I be the crybaby, like, why she cry so much? That's how I be feeling, for real. For real, Bobby, that's how they make me feel when I have to beg for likes. All right, guys. Much kisses to all of y'all. Big kisses to those that hit the like button. Thank you. Okay, I'm going to give y'all a kiss again. Thanks. Thank y'all. Let's see what else. Oh, what was your question? Okay, Coco, let me go up and see what was the question. My bad, Coco. I didn't know you asked me a question. So now the judge has to make a decision on these motions. Tomorrow, that's what the motion hearings are all about. They're gonna have to make a decision on all those motions. They gotta put an argument about the motion, and then he makes a decision based on the information provided. Off the topic, any good news about the baby? Okay. I think I'm gonna have my own live. I'm gonna have my separate live on that one because I don't want to mix it up with everything. Because I am gonna share with you everything that's happening. I told you I was gonna share, and I didn't take time to share it with you guys, but I'm gonna share everything that's happening in the next live. Okay? Okay? Okay, let's see what else. Let's see. I gotta find my own personal sound effect. It doesn't give me any other ones. I guess I gotta pay for more ones if I want more. Let's see. I wonder how do you get more? How do you get more on this thing here? It doesn't give you an option to get more. It doesn't give you an option. Yeah, it doesn't give me an option. Let's see. How do I import more? Oh, I can import my own sounds. Okay. Okay, I don't have any sounds to import. Maybe I need to record my song. You know what? I'm gonna record some stuff that I say, and then I'm gonna have my own little I'm gonna import my own little wordings in here. You know, I'm gonna say, "Come on, guys, hit the like button." You know what? That's what I'm gonna do. I'm gonna start recording my own little things, and then when we put it on, you guys could yeah, that's what I'm gonna do. That's what I'm gonna do. Silly Sil. That's my name. That's my name. Let's see. I'm going to do the recording here. All right. I'm going to go ahead and end this live. Guys, any question before I end? You guys, was that good enough of update that I've been missing you guys and just like not giving y'all an update? You know, today is a slow day. I understand, but do you guys need more attention? Well, I'm about to get my butt on out of here. While I'm riding to go get my hair cut, I'm gonna share with you the whole thing with Peanut. My hand is hurting so bad. My hand, Arthur's hit my fingers. But thank you guys for all you guys which I do. Thank you so much. I'm gonna have these recording so I can have some audio. Talk to you guys later. Love y'all. Bye. Oops, hold on. All right, bye. Later. Alligator. After a while. Crocodile.